This was such a disappointment on so many levels. First of all, from a purely political standpoint, this is very clearly, obviously, a normal question on the census. There's no constitutional provision that would prohibit asking a person whether or not they're a citizen on the census. In fact, it makes perfect logical sense, even for the time that when the census was invented, at the time of our Constitution's writing. It makes perfect sense. This question has been on our census until the 1950s, and then from 1950 until 2010, it was on the long form version, which was sent to about 1 in every 6 households. It was on there, the long form version, until 2010 when President Obama removed it. So there's only been one census in the history of our country that has not included this question.
Yeah, crazy ruling from the chief here. It's funny, I was on with Glenn Beck this morning, and what I told Glenn is I would put this opinion up there in the John Roberts Hall of Fame right alongside the Obamacare decision. This is classic Chief Justice Roberts, truly classic. The way at the beginning of the opinion, he kind of fools you a little bit. He's kind of pulling us along. And when this broke on Twitter with SCOTUS blog and everyone who was live tweeting it, the initial news reminded me a lot of the Obamacare case, because in the Obamacare case, we first saw that the mandate was actually not going to be upheld on Commerce Clause grounds. It wasn't until a few minutes later when we realized what the chief had done in terms of rewriting it as a tax. Very similar thing here. That including citizenship question is not foreclosed by either the Constitution or the Census Act. So there's both constitutional and statutory authority to do what Secretary Ross and the Trump administration are trying to do. But they are questioning whether the private motives align with the publicly stated rationale. It's an insane ruling. It actually reminds me kind of the so-called travel ban litigation, Liz. If you recall, at that time, some of these courts, like the Fourth Circuit up in like Maryland and Virginia, they were quoting Trump's tweets from the campaign as if that was some sort of insight into his private motivations, and they were trying to discern whether that was a proper justification. This is insane. Clarence Thomas, it's technically a partial concurrence, partial dissent, but it's really a dissent. And his dissent versus holding today basically says, we are there to assess the legality of this action. The court says it's legal. Our inquiry stops there.
Right. Right. It's not their role, essentially, to talk about the wisdom of a policy. It's to talk about whether they think it's a good policy, whether they think it's a bad policy. Not their role. That's the role of the legislature. Their role is only to determine whether it falls in line with our Constitution and with our existing law. So basically the judgment here, this is why it was so confusing for people. It's affirmed in part, reversed in part, and remanded to a lower court. So everything that it could be